What if I told you that buried inside a plea deal signed in 2008, there was a clause, a single paragraph, that granted criminal immunity not just to Jeffrey Epstein, but to an entire list of other people? Some of them named, some of them not. What if I told you that the federal government agreed in writing to shield unnamed individuals from prosecution? Individuals described only as potential co-conspirators, and that the victims whose lives were destroyed by those very people were never told this deal existed. This isn't theory. This isn't speculation. This is a signed federal agreement, and it sat hidden from the public and from the victims for years. Stay till the end, because the language of this agreement, the actual words chosen by federal prosecutors, will change how you understand everything about this case. I'm Mark Epstein, and this is the Epstein Files. The date was September 24th, 2007. The place, the offices of the United States Attorney for the Southern District of Florida in Miami. On that date, the Office of United States Attorney R. Alexander Acosta entered into formal negotiations with the legal defense team of Jeffrey Edward Epstein over the terms of what would become known as the Non-Prosecution Agreement, the NPA. Source: PACER, Case 08-80736, CIV, DOJ OPR Report, November 2020. By this point, the FBI had spent more than a year investigating Epstein. Agents had identified approximately 36 victims, most of them minors at the time of the alleged offenses. Assistant United States Attorney A. Marie Villafana had prepared a federal indictment, reported to be 53 pages long, that laid out charges serious enough to put Jeffrey Epstein in prison for the rest of his natural life. Source: Miami Herald. Perversion of Justice, Part 3, referenced in Case 08-80736, CIV filings. On the other side of the table sat one of the most expensive and powerful legal defense teams ever assembled for a criminal case. Jeffrey Epstein's attorneys included Alan Dershowitz, the Harvard law professor; Roy Black, one of South Florida's most prominent criminal defense lawyers; Jack Goldberger, a veteran Palm Beach criminal defense attorney; Gerald Lefcourt, a leading New York defense attorney; Kenneth Starr, former independent counsel; and Jay Lefkowitz, a Washington attorney and former special envoy. Source: Case 08-80736, CIV filings, Miami Herald. Perversion of Justice, Part 2, DOJ OPR Report, November 2020. Negotiations stretched over months, and in June 2008, the Non-Prosecution Agreement was finalized and signed. Source: NPA document, PACER, Case 08-80736, CIV, DOJ OPR Report, November 2020. But here's where it gets disturbing. The NPA was not a standard plea agreement. Standard plea deals resolve charges against a defendant. They address what the defendant did, what the defendant will plead to, and what sentence the defendant will receive. The NPA did all of that. Epstein would plead guilty to 2 state charges in Palm Beach County, 1 count of solicitation of prostitution and 1 count of procurement of minors for prostitution. He would register as a sex offender and serve 18 months in the Palm Beach County stockade. Source: NPA document, Palm Beach County Court Records, Miami Herald. Perversion of Justice, Part 3. But the NPA went much further, far further than any ordinary plea agreement. The agreement contained a clause, and I want to be precise about the language here, because the words matter, that stated the United States Attorney's Office agreed not to institute any federal criminal charges against Jeffrey Epstein or against any potential co-conspirators of Epstein. Source: NPA document, filed in Case 08-80736, CIV, DOJ OPR Report, November 2020. Read that again. Any potential co-conspirators of Epstein. The agreement included a list of names, 4 women were specifically identified in the NPA as having received immunity from federal prosecution. According to court filings and the DOJ's own Office of Professional Responsibility report released in November 2020, the named individuals included Sarah Kellen, Adriana Ross, Leslie Groff, and Nadia Markinkova. Source: NPA document, DOJ OPR report, November 2020, case 08-80736 CIV filings. Each of these women had been identified by victims as playing operational roles in Epstein's network. According to victim depositions filed in the case of Virginia Giuffre vs. Ghislaine Maxwell, case number 15 CV 07433 in the Southern District of New York, and corroborated in other court filings, these individuals served functions ranging from scheduling appointments with the victims to being present during encounters at Epstein's residences. Source: Case 15 CV 07433 filings, referenced in Case 08-80736 CIV. Sarah Kellen was described in multiple victim statements as one of Epstein's primary schedulers. The person who arranged for girls to come to 358 El Brillo Way in Palm Beach. Adriana Ross, also known as Adriana Muchinska, was described as being present during encounters at the Palm Beach residence. Leslie Groff was identified as Epstein's executive assistant who scheduled travel and appointments. Nadia Marchinkova was described in victim depositions as someone who participated directly in sexual encounters with victims at Epstein's direction. Source: Victim depositions referenced in Case 08-80736 CIV, Case 15 CV 07433, Miami Herald, Perversion of Justice, Parts 2-3. These 4 women were named in the NPA. They received explicit immunity from federal prosecution. But the clause did not stop at those 4 names. Now, if you're still here, it means you can handle the truth. So let me show you what they didn't want you to see. The critical phrase in the Non-Prosecution Agreement was not the list of named individuals. It was the broader language, the words, any potential co-conspirators. That phrase created an open-ended shield. It did not define who those co-conspirators were. It did not limit the immunity to the 4 named women. According to the plain language of the agreement, and as analyzed in subsequent court proceedings in Case 08-80736 CIV, this clause potentially extended federal immunity to anyone who could be characterized as a co-conspirator in Epstein's network of abuse, whether they were named or not. Source: NPA document, Case 08-80736 CIV filings and judicial analysis, DOJ OPR report, November 2020. Consider the implications. The FBI's investigation had not only identified victims, it had identified a web of individuals who facilitated, enabled, or participated in the trafficking of minors to Epstein. The scope of the investigation extended well beyond 4 assistants and schedulers. The most prominent name absent from the NPA, but later charged in connection with the Epstein case, was Ghislaine Maxwell. Maxwell was not named in the NPA's immunity provisions. However, the question of whether the agreement's broad co-conspirator language could theoretically extend to shield her, or others, became a significant legal issue. Source: Case 08-80736 CIV filings, later addressed in Case 20 CR 330 proceedings. When the Southern District of New York indicted Ghislaine Maxwell on July 2, 2020, case number 20 CR 330, the charges were brought by a different federal jurisdiction than the one that signed the NPA. The NPA was an agreement of the Southern District of Florida. The SDNY indictment was brought by the Southern District of New York. Maxwell's defense team raised the NPA as a potential bar to prosecution, but the SDNY argued, and the court agreed, that the SDNY was not a party to the agreement and was not bound by its terms. Source: Pacer. Case 20 CR 330 DOJ press release, July 2nd, 2020, Maxwell trial proceedings. But that jurisdictional distinction raises its own question. If the NPA's immunity clause was broad enough that a defendant in another jurisdiction needed to argue it as a defense, what does that tell you about the scope of the protection that agreement was designed to provide? And there is another layer to this. The victims were never told about the NPA. This is where the official story falls apart. Under the Crime Victims' Rights Act, 18 U.S.C., paragraph 3771, enacted in 2004, victims of federal crimes have the right to be informed of any plea bargain or agreement involving the defendant. They have the right to be heard. They have the right to confer with the prosecution. The NPA was finalized in June 2008. Not a single victim was notified. Not a single victim was consulted. Not a single victim was given the opportunity to object. Not to the lenient charges, not to the county jail sentence, and not to the extraordinary immunity provisions that shielded the very people the victims had identified as their abusers' enablers. Source: Pacer, Case 08-80736, sirf, Mara ruling, February 21st, 2019, 18 U.S.C., paragraph 3771. In 2008, attorneys representing two victims, identified as Jane Doe No. 1 and Jane Doe No. 2, filed suit against the United States in the Southern District of Florida, case number 08-80736, CIV, arguing that the government had violated the CVRA. Source: Pacer, case 08-80736, CIV. The case was assigned to Judge Kenneth A. Mara. That case moved through the court for over a decade. And on February 21st, 2019, Judge Mara issued his ruling. The United States had violated the Crime Victims' Rights Act. Source: Pacer, case 08-80736, CIV. Order, February 21st, 2019. The government had been required by law to inform the victims of the NPA and had failed to do so. The DOJ's Office of Professional Responsibility, in its report released in November 2020, acknowledged the CVRA issues. The report concluded that U.S. Attorney Alexander Acosta had exercised poor judgment in several aspects of the NPA negotiations, but did not find prosecutable professional misconduct. Regarding the immunity provisions specifically, the OPR report documented the internal deliberations. AUSA Villafana had expressed reservations about the scope of the immunity. Every file matters. I'm Mark Epstein, and I'll see you in the next file. The report also documented that Epstein's defense attorneys, particularly during negotiations in late 2007, pressed aggressively for the broadest possible immunity language, seeking to protect not just Epstein, but those in his orbit. The final language of the NPA reflected significant concessions to the defense on this point. Now consider this timeline. In 2007, Alexander Acosta's office was negotiating immunity for unnamed co-conspirators. In 2008, the deal was signed and sealed, hidden from victims. In 2019, a federal judge ruled the victims' rights were violated. And it was not until July 6, 2019, when Jeffrey Epstein was arrested by the FBI NYPD Crimes Against Children Task Force at Teterboro Airport in New Jersey, upon returning from Paris, that the federal government, through the Southern District of New York, brought new charges. 11 years after the NPA. 11 years during which the immunity clause sat in place. 11 years during which potential co-conspirators, named and unnamed, were shielded from federal prosecution in the Southern District of Florida. The question that this episode cannot answer, because no court proceeding has answered it, is this. Who else, beyond the four named women, was intended to be covered by those words, any potential co-conspirators? How many individuals were effectively protected by a single paragraph in a plea agreement that the victims never saw? And who made the decision that the scope of immunity should be left deliberately broad? And why? What we know is what the paper tells us. The NPA is a public document now. The OPR report is public. Judge Mara's ruling is public. The indictments in the Southern District of New York against Epstein in 2019 and Maxwell in 2020 are public. The Maxwell trial transcripts from November 29th through December 29th, 2021 are public. The victims' depositions are in many cases public. And all of those documents point to the same conclusion. In 2008, the United States government signed an agreement that did not simply let Jeffrey Epstein off with a light sentence. It built a legal wall around an entire network, a wall that stood for more than a decade. A wall that the victims had to fight in court for 11 years to begin to tear down. As we explored in episode 21, the failure began with the Palm Beach County Grand Jury in 2006, when State Attorney Barry Krischer's office presented the case in a manner that yielded a single misdemeanor charge. As we will explore in episode 26, the terms of Epstein's incarceration under this deal, the work release arrangement in Palm Beach County, turned even the punishment into a privilege. But this episode is about the immunity clause, because that clause is the reason this case is not just about one man. It is about a system, a legal mechanism that was used to protect the unnamed. And until every name covered by that clause is known, this story is not over. The powerful bury the truth, but paper has a longer memory than power. If this episode opened your eyes, hit subscribe and the bell icon, because every file matters. Comment below, should the full scope of the NPA's immunity provisions be investigated by Congress? I read every single one. Share this before it disappears from your feed. Next file, the work release. How Jeffrey Epstein, a registered sex offender serving an 18-month sentence, was allowed to leave the county stockade for 12 hours a day, 6 days a week, to go to a private office. When you see the arrangement, you'll understand that even the punishment was designed to be no punishment at all. I'm Mark Epstein, and I'll see you in the next file.